Welcome back to LAWSTACHE channel. My name is Anton Vialtsin. I'm an attorney in the Southern District of California here in San Diego. If you've been paying attention to the developments in the Second Amendment arena, you should know about the Bruen decision. This was the Supreme Court decision that created a new way on evaluating the constitutionality of Second Amendment statutes, which means that rather than doing any sort of balancing test, the courts should engage on trying to look at the history and traditions of this country while evaluating the statute. With this renewed interest in the Second Amendment, we have a bunch of circuits now debating who, when, and how can possess firearms in the United States. Some of the interesting cases that we now have is whether a felon in possession, somebody who has previously been convicted of a felony, meaning that they've served at least 1 year in prison, or at least have been charged with a statute that had maximum penalty of over a year in prison, whether those people can possess firearms. Another example is whether somebody who is subject to a restraining order can possess firearms. There's now all these circuit splits. Some of these cases will go up to the Supreme Court. But if you've been paying attention to my channel, you should be also aware of the Fourth Amendment, the one that protects you against unreasonable searches and seizures. There's often an intersect between the Second and the Fourth Amendment. It is by searching and seizing the firearm is how the law enforcement might be infringing on your Second Amendment rights. When law enforcement are dealing with firearms, they might be getting tips from the general public. So the question becomes, if you have an individual who calls 911 and reports that somebody else has a firearm, what can law enforcement do with that information? Can they go to the scene and stop that individual? Can they search them? Can they take the firearm? That's the question we're going to answer today. And before we go on, I want to thank you for watching me on YouTube, hitting that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support this channel, consider going to lawstache.com and check out some of the merch, including the Do Not Arrest This Person t-shirts. Thanks for watching.
Quick message from LawStache. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vialtsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the LawStache YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the LawStache YouTube page. That's LAWSTACHE.
Today we'll be discussing Florida versus JL, a Supreme Court case that deals with the Second Amendment, Fourth Amendment, and the stop and frisk policies that are used throughout the country. First, let me give you some factual background. The facts are here really straightforward. We have an anonymous caller reporting to the police that he sees a young black male standing at a particular bus stop with a firearm. He also reported that the individual was wearing a plaid shirt. Officers get dispatched, they get to the scene, they see 3 black males standing at the bus stop, and one of them, JL, was in fact wearing a plaid shirt. They observe the 3 individuals for a few seconds, they don't see the firearm, and they don't see any unusual movements. Nevertheless, the officers decide to frisk all 3 individuals, and they find a firearm on JL. Now, he gets charged with possessing a firearm that's concealed and also possessing a firearm for somebody being under the age of 18. This explains in the case why JL is named JL. He was a minor at the time, only 16 years old. JL now moves for the suppression of the firearm and says that it cannot be used against him in trial because it was found in violation of his Fourth Amendment rights against unreasonable searches and seizures. Now we have to begin by looking at the decisions on the quote-unquote stop and frisk policies that began with Terry versus Ohio. The court held in Terry where a police officer observes unusual conduct which leads him reasonably to conclude, in light of his experience, that criminal activity may be afoot and that the person with whom he is dealing may be armed and presently dangerous, where in the course of investigating this behavior, he identifies himself as a policeman and makes reasonable inquiries, and where nothing in the initial stages of the encounter serves to dispel his reasonable fear for his own or others' safety, he is entitled, for the protection of himself and others in the area, to conduct a carefully limited search of the outer clothing of such persons in an attempt to discover weapons which might be used to assault him. Here, the officer's suspicion that JL was carrying a firearm did not come from their own observations. Remember, when the officers got to the scene, they did not see anything illegal. Instead, they were relying completely on the anonymous tip. Now, unlike the information that comes from a known informant whose reputation is on the line, or who can later be charged with providing fabricated information, anonymous tips seldom provide the basis for knowledge and veracity. So, how do we know that the information is accurate and provides reasonable suspicion? Now, the court says and makes a distinction between the information that's predictive, meaning if the caller can predict the future. For example, telling the officers that a suspect would be driving a particular vehicle from one location to another, he would open up the trunk, take out a box, and take it to a certain location. Now, this is predicting the future, which means that most likely the caller has some basis for knowledge.
In 1990, in Alabama v. White, this court held that anonymous tips can justify police frisks, but only if they present signs of reliability adequate to arouse reasonable suspicion. In that case, an anonymous caller told the police that a certain woman was carrying cocaine. The caller described not only the woman, but what she was about to do. She would leave a certain building, drive a certain car along an identified route. Only after the police observed the woman acting as the caller said she would, we explained, did it become reasonable to believe that the caller had inside information about the woman, and on that account to credit the caller's report of the woman's cocaine carriage.
Here, there is no predictive information. The only thing that the anonymous caller said was the fact that JL would be wearing a plaid shirt. And there's nothing criminal or illegal about wearing a plaid shirt. It simply helped the law enforcement to identify JL, but it did not provide any reasonable suspicion that JL was committing a crime.
But the tip reliability necessary to justify a stop and frisk is not just accuracy in identifying a particular person. The tip most essentially must bear signs of reliability regarding the charged conduct, here the unlawful carriage of a weapon.
Now, the government also tries to create a quote-unquote firearm exception, that anytime there's a tip about a firearm, law enforcement should be able to stop and frisk an individual. Now, the Supreme Court refuses to create such an exception. So at the end of the day, here's what the rule that comes out of this case about the anonymous tipsters and the Second Amendment. There's one simple takeaway from this case. An anonymous tip that a person is carrying a gun without more is not sufficient to justify law enforcement from stopping and frisking that person, period. So I hope you learned something today, and if you enjoyed this video, give it a thumbs up. Every Wednesday, we go into a deep dive on one case and try to understand the law, and every Friday, I give you a short video where we discuss briefly some of the news that are happening this week in the legal arena. So I hope you like this video. Give it a thumbs up. Please subscribe to my channel, share it with your friends and family. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support this channel, consider going to lawstache.com and check out some of my merch, including the Do Not Arrest This Person t-shirts. Thanks for watching. See you on Friday.